we initiate chaos. Theory guarantees that we'll play like lightning shots, sounding like thunder. For every time in the face that it hits us, we're faster. Well, they should know by now. They see the world keeps trying to shake us. It only waits us. The pendulum swings. The pendulum swings. It's in a beautiful darkness. Only another. It's full steam ahead. Full steam ahead. All about the Petty Express. Misdirected from the start. It's a runaway train. I come a freight train. I come a freight train. In a beautiful darkness, the Petty Express. In a beautiful darkness.
Hey, you guys, it's Mo from Mo in the Deep End. This is the Petty Express. Look, I had to put wig glue on, so I'm not taking the wig off. So there you are. We are back. We did manage to skip through a lunch break. And yeah, I got cold, so I put on, yeah. Well, I was mother of ferals, since humanity and, well, the rules that govern the universe have realized that having my own dragon is probably not something I would use for good. Let's be real. I too would be tempted to set some things right if I had a dragon. Do not forget we've got bingo going for today, so get your free. And we are still in the state's case, or not the state's case in chief, the defense case in chief. And, we just got done listening to Chris's mother. If you remember, she did have custody of the children. Depending on wig budget, I totally could. But that's really for all jobs. Depending on wig budget, I totally could probably deal with them. Let's get into this and get some more of this case chipped away so that we can, get a little bit. True.
In the matter of the state of Georgia versus Christopher Wolfenbarger, case number 24SC004201.
We are at
I'll note that Mr.
1.25.
Wolfenbarger is in the courtroom. And before we adjourned for lunch, I had asked Mr. McDermott if you'd had a chance to discuss with your client the choice to testify or not testify, and if a decision had been made in that regard, so that I could go ahead and have a conversation with Mr. Wolfenbarger about that. And so you requested at the time to wait and let you have further conversations with your client during lunch. And so have you had a chance to have those conversations, Mr. McDermott?
Yes, ma'am.
Okay. So is now acceptable to you for me to inquire with Mr. Wolfenbarger?
Yes.
Okay. Mr. Wolfenbarger, so I'll tell you, like I tell witnesses, I'm fixing to ask you a series of questions, and when you answer, I'm going to need you to answer out loud so that the court reporter can take down your response. Do you understand, sir? Okay. So, Mr. Wolfenbarger, do you understand that you have a right to testify in this trial, and that if you want to testify, that nobody can prevent you from testifying?
I do.
Okay. And do you understand that nobody can make you testify? That is, you have a right to not testify if you don't want to.
Yes, ma'am.
Okay. And do you understand, sir, that you, not your lawyers, are the person who makes the decision whether you will testify or not testify?
Yes.
And do you also understand, sir, that if you do not testify, then upon request by you or your counsel, that I will instruct the jury that your decision not to testify cannot be used against you in their deliberations?
Okay.
Okay. So you do understand that?
I do.
Okay. And do you understand that if you choose to testify, you won't just get asked questions by your own lawyers, you will also be subject to cross-examination by the state's lawyers? Do you understand that, sir?
I do.
Yeah, you're going to have to get cross-examined by Adrian Love. That alone would keep me off the stand. Mostly because I would get irritated at her lack of, being able to take information from my sentences and, ask a different question.
Okay. Now, I don't want to know what you've discussed with your attorneys, but have you had a chance to discuss with your attorney the decision whether you will testify or not testify?
I have.
Do you need any more time to talk to your lawyers about that decision?
No, ma'am.
Okay. Having had an opportunity to talk with your attorneys about that decision, do you wish to testify in this case, or do you not wish to testify?
I do not.
You do not wish to testify. Is that correct?
That's correct.
Okay. So thank you, Mr. Wolfenbarger. Based on your responses to my questions and your representations regarding having had ample time to discuss that issue with your attorneys,
I think this is a good choice. We need to get next time Runkle's in the state, I need to try states. I'll just wear the Daenerys wig. So there we go. We can do a runkle off. Instead of dressing up as anything else for Halloween, all law tubers should dress up like Runkle for next Halloween.
Find that Mr. Wolfenbarger has made a decision to not testify, and that decision has been made with an understanding of his rights, and that decision is knowing, voluntary, and intelligent. The second issue I wanted to take up with y'all is, it might not matter at this late hour, but my understanding is that the Sheriff's Department has now acknowledged that warrant and said they are taking care of it. So I don't know what that means, but it is what it is.
That's what the deputy told me as well, and it's unclear how we can kind of monitor it, but I know in the past when I tried to call the warrant division, they rarely give me much information, but I take their word for it. They're working on it, and we'll either stay in touch with you or maybe the DA's office.
Now, as far as Chris not taking the stand, I don't think he has to. I mean, now if the state had brought a stronger case, if, they had marked off and gone through, Norma and Carl's whereabouts and the weird guy from Waffle House whereabouts, I think Chris would have to testify as to, where he was and try to, but I think him not taking the stand in this is perfectly right. And I am not sure. I will have to dig into what the warrant is about, because this is the first I'm hearing of a warrant. And hi, Christine. Christine is an OG. She has been watching since, I had much less wigs. Yeah, take the stand only if you have no other choice. I mean, Adrienne Love, this may be the one day that she's able to ask Matlock-style questions, and you never know.
And I can try calling the warrant division. I just know they're usually very reluctant to get information on the phone. So
Okay, thank you. Now, the other thing I wanted to take up, I don't know how long it might take and where we are in terms of how much more time we might need with the jury today before we would be ready to for the case to be done. But we do still need to revisit the matter of the motions that the defense wanted to put on the record in terms of any motions at the close of the state's case. As we put on the record earlier, in an effort to be efficient with the jury, we went ahead and reserved your opportunity to raise those objections or those motions after we went ahead and proceeded with the state resting in front of the jury and then y'all going forward with some witnesses that you had.
Fair point.
Yes.
Okay?
At this time,
This is an odd thing procedurally. So kind of generally, and I guess it sounds like they all, came to a plan and agreed upon this together, the state, the defense, and the judge. But typically this is done in open court right after the state rests their case. For appellate reasons, you have to, make your notices that the state didn't meet its burden and any objections you have with the state's case at that time on the record, or it's basically you don't get to pick up that appellate point later if you didn't make it right now. It does seem like she's a little stopped up, but I have her at 1.25 because they talk, maybe it's the Midwest in me, but they are completely slow to me. So I always speed them up.
by the state's having rested its case, we would move the court for a directed verdict of not guilty on both counts. On malice murder, the state has not proven it has not given any evidence of a cause of death. They have not shown any evidence that Christopher caused Melissa's death. They've not shown any evidence that she died unlawfully. On felony murder, they've not given any evidence that an aggravated assault occurred. They've not given any evidence that an assault occurred. They've certainly not given any evidence that it occurred with an object that could result in serious bodily injury. And they've certainly not also given any evidence that an aggravated assault occurred that caused her death. And they've not proved the cause of death.
What I think he's trying to put out there is that the torso, basically they checked all the skeletal remains, all of the limbs and the skull that were found were cleaned. The bones were cleaned to keep it as, not grody as possible. And there weren't any markings that would have been indicative of anything other than dismemberment. So really, they don't know what caused her death. Maybe if we do eventually find a torso or the bones, there might be, some indication of bullet wound or stab wounds, but we haven't found that. So the state essentially brought a case in which they don't know where this happened. They don't know how it happened. They don't know who did it, but they want you to look at all of the kind of circumstantial stuff and send this man away for the rest of his life. And I'm sorry, state of Georgia, even the jury said you didn't do a good job.
In neither case have they proved an intent to carry out either an aggravated assault or a murder with malice aforethought. In this case, Your Honor, is the evidence of guilt is only circumstantial, and the court must rule out every reasonable hypothesis that would support his innocence. They have not ruled out the fact that other people, including the victim's parents, including the victim's uncle, Martin Eric Jackson, including any number of random people in the area, could have carried this out. There are a number of reasonable hypotheses, and we've given evidence for some of them. And the court is authorized to apply that standard in granting a directed verdict. Just a second, Your Honor, please.
Sure.
The state has given some evidence from which, from what we've talked about with prior difficulties regarding the incidents of alleged domestic abuse that occurred in July of '98 and at some undetermined time before that.
And yeah, that's the only thing that the state has been able to bring concretely. I mean, there were allegations that Chris was fired from the glass shop that he was working at, very near to where the body was found, or body parts were found, that he had stolen a skill saw or one of the little, here, let me draw, I've got a, because I don't know what the thing is named, but I can draw you a picture of it. Well, a facsimile of what it looks like. So it's one of these dealies, a hacksaw, or basically it's not a saw, but it's electrical. And look, I'm not Tim the Tool Man Taylor. I work on home improvement, so I don't know anything beyond that. But there were allegations that he stole that, but they didn't link the blade style or the cutting marks on the body to that particular, kind of tool. I mean, we had this in the Chandler Halderson case. If the tool marks are there and the anthropologist is skilled enough, they can tell you which saw made which cut based on the depth and kind of the characteristics of the cut. So they didn't even do that. Again, I don't know who decided to take this half-baked, half-finished case to trial, but it was a terrible idea.
When you're considering what a reasonable juror, well, I think your jury instructions covered as well, as far as what a reasonable juror would be allowed to consider as toward the elements of the crime, they cannot consider or infer character. They may not infer from those things that he had the character to commit other such crimes or wrongs later. In other words, they can't use that as propensity evidence. So they can't say, well, he did this, he may have hit her on one other occasion, so he must have done it later, and therefore that fulfills one of the elements of the crime. They can't do that, and this court can't consider that. And as far as prior difficulties are concerned, the finder of fact is only allowed to use that to consider a state of feeling.
Maybe that's what it was.
So I would say there's abundant lack of evidence in this case of intent and of the elements of the crime, and so we would request the court grant directed verdict at this time.
Thank you, Mr. McDermott. Who will I hear for the state?
Me, Judge.
Mr. Fassett,
Yes.
your response?
You know, it's like two cases. There's a. My computer
Wait,
goes.
Georgia's brought bullshit cases before that you've won? I don't know if that's arguing your case as well. You think you'd have the cases pulled up, sir? You had 5 minutes while the other lawyer was
two
talking.
cases as authority for the court to base this decision on. The first case is Odom versus Hughes. That is a Georgia Supreme Court case, 293 Georgia 447, 2013. Second case is Miller versus Lynch, 351 Georgia Pellet, 361, 2019 case. It ultimately speaks to a decision before the court when there's a conflict and when there is no conflict in the evidence that's been presented by the state.
Miller states the trial court may direct a verdict only if there is no conflict in the evidence as to any material issue, and the evidence introduced with all reasonable deductions therefrom shall demand a particular verdict. Where any evidence, even slight evidence, supports the opposing party's case, the directed verdict is improper. So, first, the state is not required to prove evidence of motive, but the jury is authorized to consider evidence of motive. In this case, I would cite evidence of 3 different potential motives for this defendant to murder Melissa Wolfenbarger. First was the pending state court case from the July 1998 incident.
Yes, but it seemed like Melissa was surrounded by people that had potentialities or potential motives. Therein lies the problem. You went full hog on Christopher, who is not a saint. I'm not defending his actions. But you didn't look at the parents who had a kind of reputation, a history of red rum for solving problems.
There was a battery, and even though Melissa wrote an affidavit saying that she no longer wanted to pursue the TPO, we know from the March 29th, 1999 date that that criminal case was still pending. I think the fact that that case was still pending and that Melissa was murdered and was unavailable to attend, her head being found a month after that case was dismissed when they couldn't locate her, I think the fact that there was a pending case, the jury can consider that as possible motive. I think that the fact that this defendant was aware that Melissa Wolfenbarger was seeing an individual he referred to as Mike, who we heard testimony from and confirmed and corroborated that. The fact that she was having an affair is another form of motive, possible motive for this defendant to murder Melissa Wolfenbarger. And we also know from Melissa's mother, the letters, and this defendant's own mouth that Melissa planned on leaving this defendant. All 3 of those are independent, separate.
You're going to Norma as a litmus for truth? Georgia's more screwed up than I thought. I would not tout Norma anything as far as credibility, but sure, stake your case on Norma.
Possible motives for this jury to consider as reasons why this defendant would want to have Melissa Wolfenbarger murdered. There are prior difficulties, and those prior difficulties further corroborate the battery that occurred on July 1998. There are 3 instances of the prior difficulties. The first in the beginning of the year, I believe it was February or March of 1998, where Tina Patton describes seeing marks around the neck of Melissa Wolfenbarger. Vividly describes that. As does the officer Marlon Sutton, describes the events that took place on July of 1998 when he, according to his report, observed bruises and abrasions on the person of Melissa Wolfenbarger. And then we have Thomas Dixon at the end of December 1998, which he's relaying information about.
Okay, let's logic this out. Let's use the whiteboard of truth on the scale of premeditation, figurative or speculative premeditation. Okay, so Chris versus parents. So Chris potentially had what? Maybe a misdemeanor, possibly 1 to 2 years in jail, possibly. So let's say he gets, let's even round it up, 2 to 5 years in prison for the allegations of DV. So that's what he was looking at. Now, she had already given away custody of the kids, so really the kids play no factor in this. She'd already pretty much stepped away from life, him in his life. So, I mean, honestly, those are what I've got. So maybe just rage we'll put down there. Parents, they were looking at when Melissa disappeared, no one knowing they were the Flint River killers. So they were staring down potentially a lot more prison time. So I don't know. I mean, call me crazy, but between these 2 people just doing a logic, tree like pros and cons. Now, people take each other's lives for all sorts of stupid, ridiculous reasons. It's the reason why I have a morning stream. But you're telling me, State, that you looked at these potential motives, the fact that the parents were serial unalivers had not been detected yet, though they were suspected, and they were deeply upset about the children. So, I'm sorry, Chris didn't have a reason. Chris could potentially was able to stay in his kid's life because Chrissy had already signed over permanent guardianship to his parents. So really, the only motive that the state has brought forward for Chris, not that they need to, but is that he would possibly be going to the Hooskow for 2 to 5 years. Make it make sense.
The continual abuse that Melissa endured during that period, during that year. And also, again, how she planned on leaving him.
She done left him. She was sleeping with another dude from Waffle House.
Medical examiner, Dr. Terry in particular, her testimony was that she does not, in her expert opinion, believe that Melissa Wolfenbarger died of natural causes. That is from the circumstances of the...
You came to trial with a medical examiner that basically said, you know, her skull and limbs being in completely separate plastic bags is probably not natural. Georgia, how much fluoride are they putting in your water? Do we need to get, Jesse Ventura out there to ask? I'm just asking questions. Because, yikes.
Facts that she reviewed, the fact that there were 2 marks on the person, the bones of Melissa Wolfenbarger, on the neck, on the limbs, on the femur. The fact that the bags appeared to be situated to where she was, in her opinion, murdered at a different location, that those bags were placed there very recently to the time that they were located. Because of the rip in the bag, she isn't able to tell the time of death. You know that the head had not been outside of that bag for more than a day because there were no maggots, there were no insect activity. The doctor couldn't say whether or not the remains had been refrigerated and dropped off. That was a possibility. She also couldn't say whether or not Melissa had been strangled because
could your medical examiner shine any light except, list the things that she couldn't find? Now, the skull being present, there actually is kind of a story behind that. Now, to go along with the theme of losing evidence, it was alleged by the police officers who responded to I'm just going to draw a bag because, quite frankly, the bag was picked up by a dog, as dogs do, you find trash bags. And there were allegations that there was actually a VHS tape that the police took said, look, this dog is going to look like a mutant. But basically, there was a VHS tape where the responding police officers took a tape out to capture the dog running around with a bag. So it is believed that the skull was moved to the road through the dog kind of going in the bag. But the VHS tape that one of the responding officers and detectives swore that they took was lost. So the actual evidence of there being any sort of canine or animal interference with the body was lost.
Parts of her neck were missing for her to make that determination. She couldn't say if she had been strangled. She couldn't say if she had been choked, stabbed, shot, or a number of other different manners of death, which is not available for that determination because of what was missing. And I don't believe that the defendant should be able to benefit from how well he was able to dispose of her body. The statement from Dr. Cherry is that the circumstances lead her to no other conclusion, that it's highly likely that she died of homicidal violence. And I think that that in and of itself.
Okay, highly likely is not enough to take a case to trial. And I understand that. I mean, it must have been very frustrating for everyone involved to know that this woman was probably breadcrumbed, but not have the evidence. But that's why you should have a competent investigation from the get-go so that you don't wait 20 years to try to investigate a cold case with lost evidence, with lost memories, with people who have moved in and out of prison and away.
Itself are facts sufficient enough that the jury should decide this case. I would ask that the court deny the defendant's motion.
So I agree with you absolutely regarding the murder charge, that there is evidence from which there's evidence in the record that would create issues for a jury regarding the fact that homicide occurred and the fact that Mr. Wolfenbarger may or may not have caused that homicide, are issues for the jury. So I'm going to deny your motion on the count 1 for murder. I think for largely the same reasons, I should refrain from granting a directed verdict on the felony murder. But I mean, candidly, I do have some concerns about the fact that even if there are clearly facts, the circumstances of her being found, right, that would support an inference, right, a reasonable inference if the jury decides to make that inference that the cause of her death was homicidal in nature. There's not any facts from which we can determine that any sort of weapon was used against her in any offensive manner.
And welcome, Baker Raiders. Pinned at the top of chat is a bingo card for this trial, and the spots that have been marked off thus far are the free spot, of course, ponytail lawyer, defense makes a point. So that is what we've got. Welcome, welcome. I hope you enjoy this. This case is a doozy. I do have a short whiteboard video to kind of explain it because it is all the cray-cray and a dumpster fire of a case. So welcome and buckle in because you're gonna need a seatbelt. This is like a Sharknado of a case.
So how do I reconcile that?
Well, so it is not required for it to be a weapon. A per se weapon. So it's not required that the weapon be per se like a gun. Gun's per se weapon is by statute, but any object that has a possibility of causing serious violent injury.
Right, but there's no evidence of that. That's my point. I can infer that she was killed by homicide because of, for example, a jury could infer that from the circumstances of how she was found and how her body was dismembered and disposed of. But can you also rationally infer that she must have been assaulted with an object which, when used in the manner in which it was used, is likely to result in serious physical injury or death?
Yes, you can.
Okay.
And the reason why is because
No, you can't. Now we're going into pre-crime, oh gosh, what is it? The Minority Report things. I can come up with all sorts of scenarios as to what happened to this woman, but you're supposed to be able to prove that they happened before I can charge this man with an aggravating, factor to this red rum that you've barely proved.
if she did not die of natural causes, there is the inference that there is an intentional act by the part of this defendant to cause her death, whether that is poisoning. That would be a substance that would cause serious violent injury. The aggravated assault could be the poison itself. If it was his hands around her neck and strangling her, the hands would be an object. We typically charge fists, feet, knees, elbows. All of those objects could be offensive weapons depending on how they're used. And it could be
Your incompetence and your ability to irritate me could be considered weapons grade incompetence. But you don't see me holding that against you. I'm just roasting you.
something that is man-made, like a gun, like a knife, like a belt or rope. And the point of the charging and the way the indictment is charged is because it is because there aren't parts of her that would allow for a determination, like the torso, for instance, like the neck structure. We cannot, with any degree of medical certainty, narrow down the limitless possibilities of objects that could have been used to kill Melissa Wolfenbarger. That's why, because of the circumstances of this case dictate that the indictment be charged in a way to allow the jury to consider all of those possibilities. And so the court is going to instruct the jury.
Wait, so the jury gets to Mad Libs their own speculation as to what happened to this chick? Now, as a non-lawyer, not even a third-party intervener, I have a feeling that you're supposed to prove something to us in order for us to go on speculation station.
Well, I mean, not necessarily. The DA could have elected to just charge murder, because either you can or can't prove murder. They didn't have to charge felony murder. I mean, you said we had to.
This judge is correct. It's almost like this judge pays attention and can use intelligence.
Allege it the way we did. That's if you chose to allege felony murder, right?
Right, having made that decision to charge felony murder, I think that the intent was to give the jury the ability to consider all the reasonable possibilities of objects that could have been used to commit this serious violent injury on the person of Melissa Wolfenbarger. And I'm saying it's serious violent injury because it wasn't a natural death. The circumstances create really the only reasonable inferences that this was a homicide. And so I think if...
Again, don't disagree with you that maybe the inference is that it was a homicide. The question is there a reasonable inference that it was an aggravated assault that caused a homicide?
And I guess what I'm saying is it is impossible for her to have been murdered with an intentional act.
Without having also had an aggravated assault.
That is correct. That's correct. I don't see a scenario that's possible. That's why I mentioned poison. Any object that would cause the death of Melissa Wolfenbarger with an intentional act would fit a category of an offensive weapon.
Okay. Thank you. Mr. McDermott, your response, sir?
If you dream it, they will convict. This is not the field of dreams. This is a courtroom. I'm going to need you to have evidence and not go to speculation station as the state.
What I hear the state saying is we can't eliminate every other reasonable possibility. And in the circumstantial only case, that's the standard by which it gets judged. It has to be. You're about to read jury instructions to the jury that says if the state has not excluded every other reasonable hypothesis.
Right, but that's a decision for the jury, not for me
No,
necessarily.
not only. There are cases that say that standard can be used during a directed verdict. Wood v. State, more recent one, I don't have the number here, if you want to look at it. Stack-Thorpe v. State, that was a 2004 case. It was a negative case, but they upheld the same standard. That you may use that on a directed verdict. And what I hear the state arguing is they're basically confessing to you. We have not eliminated every reasonable hypothesis. We can't tell you if it was poisoning, which, by the way, is not aggravated assault by a deadly weapon. It's a whole different category that they didn't charge. And I was going to say, and the same with strangulation. It is a separate statute under the aggravated assault statute. They didn't charge that. They charged specifically offensive weapon.
Setting aside the somewhat nebulous understanding that we all have because of the circumstances of how Melissa's body was found, am I wrong that the state is allowed to prove facts that would demonstrate in any way that it might have occurred? I mean, I understand your position is they haven't offered any facts about.
Judge, the fact that you use the word nebulous should be the key here. The fact that you are questioning yourself means that the state is trying to do some utter BS. Stick with your guns and tell the state no.
How it might have occurred, but there are different ways that someone can be assaulted in an aggravated manner, and aren't they allowed to offer facts that would prove any way that might constitute that under the statute?
Well, I mean, they can offer whatever they want as long as the court allows it. But as far as proving what they've charged in the indictment, they have to prove an offensive weapon.
Right.
Okay. It can't be by strangulation, it can't be by poisoning, and they've not eliminated, by the way, that she died of a drug overdose in somebody's house and they panicked and tried to hide the body. There's a lot of possibilities they haven't tried to eliminate. And that's what I'm trying to say. This doesn't need to go before the jury. They don't have proof that an aggravated assault happened. They don't have proof of a deadly weapon. And they don't get to say, well, just let us have a smorgasbord before the jury. It's supposed to work in the opposite direction. If you charge something, you're supposed to be bound by that.
Okay. What, Mr.
She was dismembered, but I do believe, and the ME is probably where we'll go tomorrow, because that was one of the things that Justice is a Process cleaned up the audio on. So we'll probably go back to them. But the ME did state that the only cutting marks they saw were posthumous. Yes, JWH. So basically what happened is that a skull and limbs were found in 2000. They were misidentified and not placed together. The skull was found first, and then several months later, the limbs were found. But no one made the connection in the state's evidence between the skull and the limbs possibly being from the same person. So for about 3 years, these body parts were misidentified as a young white man and possibly linked to a missing person in another county. Well, in 2003, Melissa Wolfenbarger, the missing person and the person to whom the body parts match, was then identified. Those body parts were then identified as Melissa Wolfenbarger because Melissa's parents, Carl Patton Jr. and Norma Patton, were both implicated. Carl was adjudicated guilty in the Flint River killings. Yes, the parents were serial unalivers who happened to wrap some of their victims in plastic trash bags. Now, the case is crazy. It's nuts. But basically, Norma and Carl, after Carl had been put in prison for the 5 unalivings he did in the 70s and 80s, these two, Norma and Carl, got it into their head that all they had to do was get Chris Wolfenbarger, Melissa's ex-husband, and there were allegations of DV. There were, reports made and a protective order that was dissolved. But, they basically didn't look at the parents. They went full on after Chris. Now, evidence has been lost, destroyed, misplaced. None of their experts can figure out where the dismemberment happened, any evidence. So it's been sort of a FUBAR case from the beginning, but it continues to be a FUBAR case.
McDermott, you mentioned the Stack case. Can you give me that citation?
It's Stack-Thorpe, citation 270 Georgia App 796.
Okay.
The other case is Wood v. State. It's a little older. 156 Georgia App 810.
Thank you. As I've said, I'm going to deny the motion for directed verdict on the count 1 for murder. I'm going to look at the case law, and I'm not going to rule right now on the DV on the felony murder count, which is count 2 of the indictment.
Understood.
Do we have other witnesses that we'll hear from the defense?
I have one other witness here.
Okay.
I was trying to get in touch with another one who's just not going to be available, except maybe by Zoom. Did we discuss that?
He did. He said he did.
And then the one we're trying to arrest.
Okay, so if I tell you that we're ready.
Okay, so the warrant is for one of the witnesses who decided, YOLO, why go to court? Word to the wise. Now, not that you should take my advice for it. I feel like LeVar Burton on reading Rainbow, but you don't have to take my word for it. But, just a cautious word of advice. If you get a subpoena from a court, go, or you'll get a bench warrant.
Resume for the afternoon, and you have your one witness when they're done, and you don't have another witness. Are you ready to rest? What's going to happen then, sir?
I still want that other witness here. And I'm going to ask for a continuance if she's not here.
Okay. Obviously, does the state anticipate that there will be some rebuttal just from a timing perspective?
Yes, Your Honor.
Okay.
Good
Like
one.
how much? Like a whole day's worth, or?
No, I would say at most an hour, hour and a half.
So we're still thinking, other than perhaps this witness and the request for continuance to find that witness or deliver that witness here, we're still thinking that today we can get the evidence closed in this case. Is that still reasonable to you, subject to this witness?
Well, I mean, assuming my witness, subject to the availability of that witness. If she were here, I would probably need an hour, maybe 45 minutes with her.
Okay. Okay. So anything else we need to take up before we bring the jury back in?
Nothing from the state, Your Honor.
Nothing
Oh,
from us.
God, the state
Okay,
has
we're ready for the jury.
rebuttal. Oh.
This calls.
I'm sorry. That's all.
That's okay.
These switch sides.
Okay, that's going to irritate the shit out of me. I know, but the fact that he has his laptop canted and not aligned with the thing specifically to hold things on the lectern is going to bother me. I don't know why it's going to bother me, but it's going to bother me because it's off kilter. It's cattywampus, and just push it
Come on
down.
up, sir, and when you
till
reach the
it's-
witness stand, if you'll
you
do me a
have
favor
enough
before you
room.
sit down, turn around and face the deputy and raise your right hand. He'll swear you in.
You swear I'll honor the testimony that you're about to Your Honor, I think I need to get Ms. German to admit me to the Zoom.
I'm not saying nothing, but I'm saying that this man's parole officer bought him that flannel fresh off of Walmart. I may actually have that flannel shirt. But why did he have to go with black and white stripes? I mean, of all the things that you probably shouldn't wear in a courtroom, maybe never go full plaid in court. I think this gentleman's chessboard shirt gives us the reasons why.
Ms. German or Mr. Freehoff or Ms. Johnson, can somebody admit Mr. McDermott to the Zoom?
I think I'm with the state and you think I'm a defendant.
Yes, exactly.
Okay, the odds are the odds are 100% this man has a parole officer. Look, I am totally profiling, but this man looks like he's lived the Joe Dirt kind of life. Not making fun of it, but this man has not, Yeah, this man is not a stranger to stripedy outfits, I'm alleging.
Joseph Wolfenbarger. That's JOSEPH WOLFENBARGER.
And if you would, while you're testifying, if you'll just try to lean forward into that microphone to make sure that we can hear you, okay, sir? Thank you. Go ahead, Mr. McDermott.
Mr. Joey, do you know the defendant?
Yes.
How do you know?
Sir, are you aware that you're in a courtroom? When's the last time you had a gummy? Are you in space? Do you really think that that goatee is attractive? I have so many questions. This is why I couldn't be a lawyer, because it'd be like, who told you the goatee was a great idea? I mean, your goatee has thinning.
That's my father.
Okay. And do you know Melissa Wolfenbarger?
I've no ever.
Okay. And do you know Kathy Wolfenbarger?
Yes.
And how do you know her?
That's my grandmother.
And do you live with her?
Yes.
Okay. What do you do for a living?
Mechanic, for the most part.
Okay.
I think this is the son.
Did you grow up with Kathy Wolfenbarger in her household?
Yes.
Okay. Do you remember at any time growing up, say around the early 2000s, that she took all the pictures of Melissa Wolfenbarger down from your house?
Sir, are you the last person using the Furby or Flowbee to cut your hair? Because I feel like given his hairstyle, I feel like the Flowbee is in full force. Look, I'm not your mom, but the mom in me wants to tell you to get a haircut and work on that goatee, sweetheart. You could look a lot better.
I don't really recall ever seeing pictures of her, like, in the house.
Okay. Do you remember at some point in your life being told what happened to your mother?
Yes. More so at a young age.
And what were you told at a young age?
I mean, I would say I was at least about 4,
Okay.
5, maybe.
And what were you told about
Your
her?
Honor, I
It was-
am going to object to that. That would be hearsay.
Yeah. No.
No, well, it would be hearsay as to what he was told, but the state has made a big damn deal about the fact that, Chris and Chris's mom didn't tell them, that she was disappeared. Oh, they didn't go search for her because, that's the police's job. Oh, they took down all the pictures. The state made this a big damn deal.
Exactly.
Sorry, I apologize, sir. When there's an objection, I have to just wait and not answer the question. Can y'all come here for a second, please?
Okay, how strange is it? I'm thinking, oh my God, okay, if I cut some of my wigs and put it on sticky glue, could I manufacture craptacular facial hair like this man? Yes, that's what I was thinking about. If you ever wanted to know what goes on in this brain, it's usually craft projects that will get me, sent to Nuremberg.
Wilson, the objections overruled. Mr. McDermott, please go ahead.
I'm going to attempt to get back in, if I may.
Sure.
It might help to have the current day, right?
That would help. There's a new one every day.
Thursday, August 21st.
Yes, sir.
You can mark off fashion judging. So if you had fashion judging, oh God, I feel sorry for this. Look, all joking aside, this young man has had to deal with things and knowledge of his mom being away from him by choice, or which comes with its own trauma, or violence, which he, learned about, implicating his father. So as much as we joke, I feel my heart goes out to the kids, because even though the daughter testified for the state, they've basically been pulled off or pulled off whatever their life trajectory was going to be had this not happened, and have had to deal with it in whatever ways they can. And as the queen of maladaptive coping behaviors, I'm not going to judge someone else's.
All right, we'll see if it works.
You can mark off objection and
Okay, I'll repeat the question. Do you remember what you were told happened to you?
That somebody had killed her, and that it's only so much you can tell a small child, but it was more so that it was done in a very horrific way.
and that seems, you wouldn't go into grave detail with a small child. I mean, to protect them from overhearing things, you might go into a little bit more detail because of the circumstance, but you wouldn't go into graphic, like mom's head was found in a plastic bag and her limbs were found here and it was all corroded. No, you don't say that. And we will get back to the daughter's testimony, hopefully by Friday. I'm planning to do a longer stream on Friday to go back to some of the witnesses that were lost during audio stuff. The daughter, you can tell, dealt with this in another way. It seems like the daughter and Norma re-sparked a relationship, and she took Norma's reasoning, which is understandable. If you want answers and Norma has easy answers that, your dad done did it and the justice, system is against us, it can be seen as a very noble thing to try to defend your mother against a person who's still here who hasn't paid for justice. So I don't even, hold a grudge to the daughter or judge the daughter. I judge Norma. Norma is the type that she would whisper poison like worm tongue into the daughter's ear. And to do that, to try to exonerate your husband who is already deceased, is just redonkulous.
Did you at some point move in with your father?
Yes.
And about how old were you when that happened?
It was after high school. It was,
Okay.
I can't recall the exact dates, but
Do you remember where you lived at the time?
yeah, same place he was found,
Was it
in Griffin.
in Griffin? Okay. And did anyone else live with you at the time?
Yes.
And who were they?
My little brother, Alias, and
You can go ahead and mark off hill chuck behavior, because who the hell names their child Alias? Look, when all of your progeny look like they have their own probation department, I would not go naming my kid Alias. What the hell is wrong with people? I give up. You can also mark WTF, because for the love of God, Alias rap sheet, Wolfenbarger. What the hell is going? Don't name your kids things that could possibly get them, profiled. Maybe don't.
it was mainly just us three.
Did your sister live with you at any?
Oh my God. So is Alias's alias going to be Steve? Strike that. Actually, talk to me, ABC, because I have a plot for a comedy. A kid with the name Alias who has to change his name to Steve. Think about it. Call me back. Have your people talk to my people.
Point?
No, that was before.
Did she come visit you at any point?
At what time are you referring?
This is afterwards.
Like,
Okay, let me try a different line. Do you remember at some point the defendant making a comment while watching a TV show that he knew how to dispose of a body by burying it under concrete or something to that effect?
it wasn't necessarily from a TV show. It was more so we were discussing about how Carl had gotten away with other murders, and we were talking about different scenarios.
Yeah, maybe because the state has drone on about this, the fact that Chris had talked to his son about how bodies might have been disposed, because there are allegations that Carl Patton Jr. and Norma, even though she was exonerated, or got granted immunity for testifying to in her role as, accessory after the fact. There have been, thoughts and allegations that there were many more bodies. They have many more victims to account for. So, yeah, I mean, while it might not be normal family conversation for you and I, if I had a serial, red rummer in my family, you don't think I'd be musing the hell out of that? Not to mention grifting my life with him.
And my sister had walked in later on, kind of caught half of the conversation and, kind of been standoffish about the conversation.
Okay, so a couple questions just to clarify. The context of the discussion was Carl Patton's murder.
Right.
Okay. And at some point, Chrissy walked into the room and overheard the conversation.
Yes.
Okay. Your Honor, I'd like to share screen, please.
Okay, are you in?
I am in now. And what I want to share is previously discussed self-authenticating document. It's a nationally reported news article. I emailed it to you as you requested.
Y'all can.
All right.
Ooh, we get to do newsy news in trial? Okay, that face of what the hell am I doing here, and I could be at the DMV enjoying my time better. Where is Ben Affleck's smoking meme? I mean, this man is the new face of why am I here and can I leave now? Also, have you, sir, not for nothing, but have you asked Steve Buscemi if he needs a body double? Because honest to God, if he needs to do action roles, you are a spitting image. I mean, well, not a spitting image, but close enough to be a body double. I say go for it. Live your dream. Be the Steve Buscemi that I know we all can. You can be. Oh God, bless his heart. He has a face that's bold, underlined, in all caps. Because while my mind would be okay in court, this face is contempt of court. Because when I hear stupid, my face just automatically starts doing one of these things. Sir, as a fellow contempt of court face, bold, underlined, and all caps, I feel ya. Oh my God, if there is another movie for Squidward, I need this man to be Squidward's face model.
Thank you.
All right, good jury.
You can sit there. Yes. You just stay right there.
We are going to the sidebar. The lawyers are gonna argue. Are any one of them going to have a point? Well, at least the defense will. Oh, good Lord. What happened now? Looks like we're having more issues. This court is cursed. I am telling you. Oh, here we go.
Okay. Full disclosure, I did read the article at the time to assess that assertion. Mr. Fawcett, what is the state? Or Mr. Wilson, I guess technically it's his witness. What is your position? I don't really care. Let me clarify for my record. I don't really care who argues.
I sense that, Your Honor. Your Honor, that article's, we don't have any further, I agree that it's self-authenticating, but it's an article about facts of this case allegedly told by someone.
Well, let me.
That makes it for the truth of the matter asserted.
Well, forgive me for interrupting you. Mr. McDermott, what is the purpose of offering this article anyway?
Thank you for asking. The relevance of this article is that there was an audio interview of Christopher in 2021 in his home. At one point in that interview, he's asking questions back and forth with Detective, I believe it was Sergeant Layton, and he said something about Melissa's body being found in bags. Layton jumps on that like a gotcha moment and says, I never said they were in bags. That is a point the jury could hear and presume that Christopher was asserting knowledge about how she was disposed of that he didn't have prior to that. Christopher retorts in the video or in the audio, kind of just in passing, well, it was on the internet. And this article, that's why I had to stipulate to the date of that interview, was because this article was published in a national forum 3 days prior to that interview. And it would have
Georgia, do you have a police force that even looks at stuff, or do you just kind of go YOLO, throw a dart, and, you know, just say, hey, the ex-husband did it? I mean, yes, had they wanted to keep there, and there are usually things that police investigations will leave out of the media so that they can confirm that, you know, a person that was actually there has, you know, certain knowledge that only the person that was there would have. But when their facts are leaked onto the national news, it's not like yeah, I gotcha when, you know, he just happens to Google Georgia police. Perhaps try Google or ask Jeeves, depending on your bandwidth allowances.
been fresh in his mind. And so I think the jury, the defense certainly deserves to be able to put that before the jury to see that this was not only on the internet, it was in a prominent place, Dateline NBC. And as you can imagine, was certainly have been shared family to family and say, Chris, do you know you're in this article, et cetera. I'm not going to elicit all that. The point is to just say, here's a nationally reputed article, and it would have been the source of his knowledge, or it could have been the source of his knowledge as to the bodies being in bags.
Tell me again who that conversation was. We're talking about the one in 2001?
No, 2021.
2021, thank you. And that was with Calhoun?
Shepard and
Okay.
Layton.
Okay.
And it's the one where they, basically they get into this in passing. He mentions that their body was in bags. Speaking of something that happened much earlier, right? But they're like, we never told you they were in bags.
Okay. Mr. Wilson?
Your Honor, I can't see how this is the proper witness to publish an article. I think that what he said himself is that he's offering it for the.
I would, okay, as a not lawyerologist, I would say that would be something. It does seem like the defense is trying to bring something that they would have maybe presented to Chris had he decided to take the stand, because it does seem like trying to tie up loose ends with a witness that's not at all related. And I loathe to agree with the state on this one. Like, don't make me agree with the state, but I have to be honest. This does seem kind of non sequitur or apropos of nothing as far as bringing this in with this witness.
The effect that it had upon Christopher Wolfenbarger, not Joey Wolfenbarger, but Christopher Wolf. I think that needs to come from the defendant, Your Honor. This is using hearsay, and to say it's not for the truth of the matter asserted, unless he has personal
Don't
knowledge
make
of
me
the facts
feel all
behind it,
icky by
absolutely
continuing to talk
is
now that
offered
I've
for the
agreed with
truth of the
you.
matter asserted, not what effect it had on the defendant when you're asking another person to testify as to the effect that it had upon the defendant.
Okay, well,
by showing the article.
I wouldn't let him testify about what effect it had on his father.
Okay.
Go ahead.
Well, Your Honor, showing that article is tantamount to putting it into evidence. I think he can ask if he knows. He can ask what his personal knowledge is of articles on the. But to put that article on there and that some.
Sir, stop talking. You done made a point. Now I'm actively wanting to deny the logic of your argument just because you're annoying me, which is reason number 11D12. I shouldn't be a judge.
Somehow give it a self-authenticating extra level of authenticity, so to speak. And that's improper, Your Honor. I mean, because that's what they're doing. They're trying to bolster testimony by using a news article, which is not really how it should be done.
I also, so at the time I did review the article, and I looked at some case law. And the concern I have here is that there are ways to ask Joseph Wolfenbarger, were you aware that your mother had been found? Did you become aware that your mother had been found in bags sometime before 2021 or whatever? There are ways to establish that. There are even ways to establish that news articles that were widely available existed. But The only purpose, in fact, I mean, the only purpose to offer a news story like this, the only reason that it's self-authenticating is because the idea is that the facts in there are true and can be relied upon because they are in, widely available, reputable publication.
I mean, if any one of you actually fully trust mainstream media, raise your hand, and then I would like you to come to the front of the congregation and explain yourself, because they have lied more than Elizabeth Warren and her Native American blood. Okay, there is less truth in the mainstream media than I have Native American blood. We have to segue for a moment because I have to tell a funny story. So if you've got squirrels, mark it on your bingo card. But we are getting ready to gear up to adopt my middle daughter the same way we did our oldest daughter so that she can, get more opportunities for college and things like that. And there's questions that you have to start for intake. And me being me, I forget that answering in smartass is not the way that everyone receives information. So the sweet attorney that we used, who was really good, was like, okay, I have to ask for the intake. Does she have any Native American blood? And my ridiculous behind decided to answer less than Elizabeth Warren. And she's like, I don't know what that means. Now, apparently she had me on speakerphone and her husband started laughing his butt off. And Mr. Mo is giving me the look like, could you just say yes or no and not pretend everything is a comedy bit? But once she got the reference, she thought it was funny, but Mr. Mo is constantly dealing with the fact that I have to, if something funny comes to mind rather than something that will just make the answering easier, I'm always going to pick the funnier line.
And what I need to pull up the case law that I was looking at because that was like a week and a half ago. I was looking at it like a week and a half ago, but ultimately my concern is that this is going to confuse things because it is a long article with lots of detail, some of which may or
Heaven forbid we require a jury in Georgia to read a 800 word to 1,000 or even a 2,000 word article. Perish the thought. Don't. MLS, this is the Chris Wolfenbarger case. It is a curse case. I think you would love it if you would want to cover it, but basically dismembered body parts were found in around 2000. They were misidentified and mislabeled as possibly being from a young white male, and then kind of forgotten about. Well, in 2003, a cold case actually, turned up the fact that the missing person or the decedent in this case, her parents were actually serial killers responsible for the Flint River killings. And in their witnesses, their victims had a penchant for ending up in trash bags. Melissa Wolfenbarger's torso was never found. The skull and limbs were defleshed. Basically, the state doesn't know how she was murdered. They definitely know she was murdered. They don't know how. They don't have the torso. They've lost evidence up to and including VHS videos of the skull being found. Well, the defense is alleging that the state failed to look at the parents' possible involvement along with other people in Melissa Wolfenbarger's life that could potentially also be third parties. The state decided to focus on the ex-husband, Christopher Wolfenbarger, and they basically have no evidence. They didn't search the marital home until the early 2020s. They luminoled 30 years after the possible dismemberment, didn't find anything. They have only circumstantial and inference evidence. There was a history of alleged DV in the marriage, and there was a temporary protection order that the decedent herself dissolved after a week. So there is a lot of shenanigans. That's kind of the elevator pitch of this trial. We are in the defense's case in chief. The state has been insufferable. There are audio problems and evidence problems and retention of information problems. So it's a curse case. It's great for the Petty Express. We watched this because Chris was actually found not guilty, and I wanted to see the trial all the way through to see what the jury saw. And having seen a majority of what the jury saw, I understand the not guilty. This is also from Fulton County, Georgia, the same brain trust that brought us the YSL and Trump trials that but both variously did not work.
May not be in front of the jury. And I would be worried about confusing the jury when really what I understand.
And MLS right now, I actually agree with the state, which I am loath to do, but the defense was trying to bring in an article. Chris decided not to testify, but it was an article to kind of explain away the fact that Chris Wolfenbarger knew that Melissa's body parts were in plastic bags because the finding, the IDing, and the Carl Patton Jr. serial killer case brought all of this up to the surface. Basically, he was asked and interviewed by police officers, and police officers took the fact that he knew that she was found in plastic bags as sort of the, ipso facto, if he knows about red bags or about the black trash bags, then he was the red rummer. Yes, what the defense is trying to do is to bring this article in while during the testimony of Chris Wolfenbarger's son, to kind of bolster the fact that Chris could have found out this information through the media, not needing to have been a party to the crime. But I actually agree with the state that this is being used to bolster, Chris's oh gosh, what's the word? Basically bolster Chris in that he could have known about this without Chris having to take the stand. And we have learned that one of their witnesses decided to say YOLO and not actually answer their subpoena. So there's actually an active warrant as contemporaneous to this live stream back in the past, where they were actually looking for their final witness with the help of the police. So this case is cursed. I don't know if it's Georgia, if it's Fulton County, but we might need Buffy the Vampire Slayer to look for a hellmouth. I'm just saying.
To be talking about is what you're trying to establish is that the fact that Melissa was dismembered and found in bags was publicly available knowledge prior to 2021. And there are other ways to do that without injecting all of this narrative information that's been wrapped up in a prepackaged by Dateline NBC.
Okay. A couple of things. I just want to backtrack to what you said about self-authenticating and the purpose of it being that the facts in there are true. That's not an authentication question.
I understand it's not an authentication question.
The self-authenticating just goes to, is the source what it claims to be?
I understand, but
We're not entering any true facts. Now, as far as the whole article being coming in, I began this discussion several days ago with Mr. Fawcett. I shared with him the link, and I said I don't want to put the whole article in. I just want to have a screenshot of the one paragraph that says the body bags. And of course, this discussion is in the course of trial. You know how things go. I haven't gotten a ruling back and all that stuff. So my intention is not to put all these facts before the jury. It's just that one, and that's why along with the link, I sent a screenshot of just the beginning of the article that has nothing more than introductory material and one paragraph that mentions the bags. That screenshot also has the date on there, so I can ask him what date was this.
Yes, but what? Okay, but that doesn't alleviate the problem that if you bring it in with his son on the witness stand, why are we trying to push through, this article that is going to exonerate or give a logical reason why Christopher would know details about the case? This just isn't the witness. If this had been plain knowledge, you had an opportunity when the detectives that interviewed Chris, when they were on the stand, you could have asked these questions. If this was common knowledge and an issue, the defense did have an opportunity for every detective that has had fingers on this case to basically ask questions. This should have been brought in with them, I would think. Again, not a lawologist, but look, I'm a armchair lawyer.
Published.
Well, that's why, exactly why it shouldn't be let in, because he's using that to supplement questions that can be asked of this witness.
I'm sorry, say that again, Mr. Wilson?
Well, he's using the date, for example, the date of the article. He can certainly, as the court has already said, he can ask questions. Are you aware of these articles? Are you aware of these things? Rather than putting in an article itself.
So if I understood your Honor, that you would have a problem with confusing the jury, I think providing just a short screenshot of only the relevant information solves the 403 problem.
I'm sorry, I'm trying to find my prior research, and for some reason,
I thought she was going to be like, look, y'all, I'm just checking out of Amazon. Give me 5 seconds. Again, what I would do as a judge versus what, actual judges would do.
the Westlaw is not cooperating with me, so just give me a moment.
If you've got court tech issues,
Now I found it. So I want to take a look at that. Mr. McDermott, what were you saying, sir? I was trying to look at Westlaw and pull up my prior research.
My apologies for interrupting. I was just appending on to what we had discussed, that you had discussed the problem of confusing the jury with facts that may not be in evidence, and I think providing only the screenshot with the one paragraph and the relevant information solves that 403 problem, so there's no confusion.
Well, I mean, the screenshot that you've provided says that Mr. Wolfenbarger was arrested on August the 7th. It says he's currently in custody. It says, it tells a story about Christina when she was 3 years old, that I don't recall her testifying to. I mean, I'm looking at.
again, this is just clunky. Defense, I've been on your side, and the fact that you're cosplaying as Nick Starro helps. But stop. In the words of Legal Vices, stop while you're behind, and state, stop while you're ahead. I mean, I feel gross agreeing with you, so stop talking so I feel less the need to shower in Purell.
The screenshot that you attached to your email.
Yeah, I'm a little, don't remember those being on there.
Oh, don't tell me you tubined yourself. Was there tentacle prawn that you just sent to the judge?
Can I approach your Honor?
Well, I'm going to share my screen so you can see what I'm talking about.
Okay.
So this
May have gotten an earlier.
He fixed it. Yes, the laptop is now aligned with the lectern. I no longer am going slowly out of my mind because he had it cattywampus. Thank you, sir.
Version of the screenshot.
Okay, well, the email that you sent me at the end of our pretrial conference on
Oh, that's right, the update.
last Monday,
Yeah,
that's the screenshot that you sent me, and it has lots of information that is not in evidence and or inadmissible.
that is true.
Someone was looking at buying new shoes. Sir, I don't like those loafers on a man.
Could I just redact that and leave what's below?
So, again, I don't understand why you need this news article to establish the fact you're trying to establish, which is that at least as of May of, does that say 2001?
Yes,
Okay.
2021.
2021, because
And so the point I keep trying to make is that this was published 3 days literally before they went down and interviewed him on this point.
I understand that. But also, couldn't you have established that with Calhoun or Shepard?
I didn't interview Shepard, and yeah, it could have been.
I just mean, there are other witnesses in the case who could, okay. Here's the, yes, sir.
I don't.
No, judge, just make a choice. Don't hem and haw, or if you have to take time to look through all the lawful law. But right now they are getting on my last nerve because Ponytail, you've made your point about 15 times, and I get you. I think this was clunky, and so I take points off for clunkiness and lack of strategery, because you did have the opportunity to talk to the police officers like the judge said. But State, you've been craptastic this entire case, and I don't like you. So the fact that I have to agree with you pisses me off. So stop belaboring the point. The horse is already dead. Just make up a...
Want to hold up the court any further? If you want to rule against it,
Okay.
so be it, and we'll move forward. But it's authentic.
No question it's authentic, but it still has to be relevant and non-prejudicial, and
It's from mainstream media. I mean, they authenticate themselves, so does the BBC, so does the FBI and the CIA. The only federal department I trust is the NTSB.
It is
not-
relevant, but it's prejudicial. I understand that.
and not hearsay, or subject to an exception. And just because it can be authenticated doesn't make it not hearsay. And what I'm primarily concerned about is that it has minimal relevance for the concern. I think that the prejudicial
Dateline is like,
nature of the facts
excuse
are
me?
contained in here, which are either not in evidence or would be subject to some sort of limit. I mean, like I said, I related the stuff that was there, but even if you were to limit further what it shows, what I think I understand is that the purpose of this article is simply to demonstrate that in 3 days before the police talked to Mr. Wolfenbarger in 2021, there was a news article that said that she was found in bags. And there are other better ways that are less inflammatory and prejudicial than this narrative that's been put together and made all shiny and pretty by Dateline NBC. Okay.
Pretty
Anything else that we
Dateline.
need to, and just to be clear, I understand I didn't give you a ruling, but I need y'all to,
Just to be clear, none of you have done anything but blather and bloviate over the essential same facts. Stop it. Just do not put the clip in. This is why I would not function well in an office. My weaponized ADHD would be like, could this have been an email, and could you have had a meeting when you figured all of the policies out? And have a wonderful lunch. Thank you for all of your Modly Mod duties, and I hope you're having a great Wednesday, Wolfram. Thank you.
let me know again when you need a ruling, right? Like, that was 2 weeks ago. So, or, you know, so.
In all fairness, I definitely tried to make that happen.
Well, I mean, you sent me an email, I understand that, but I've asked any number of times what other matters the parties need me to take up, and at no point did somebody say, oh yeah, there's this news article I want to ask Joey Wolfenbarger about, and you haven't ruled on that, Judge, or...
Okay, you guys can have your old married couple argument where he didn't tell you that the milk needed, you know, we were out of milk because he left the jug in the empty jug in the refrigerator. Y'all can have that conversation on the drive home. And the fact that he, you know, watched, 3 episodes of Yellowstone without you.
Or, in fairness, did the state say, hey, Mr. McDermott wants to offer this news article that we object to? Nobody brought that to my attention. So I apologize that we had to do it on the fly with the jury stepping out. But there's a reason I asked 87 times, is there anything else that y'all want me to address before we do whatever we're doing?
Understood.
Okay, thank you.
The judge is warning them. She is going to turn this trial around. No one is going to Wendy's, and ain't no one getting a Baconator or a Frosty if this shenanigans continues.
So are we ready for the jury to come back, Mr. Wilson?
Have a great
Mr.
day,
McDermott.
you and
Let
little
me ask one
man.
more question.
Yes.
I don't have any other questions for this witness except one. I was going to take a previously admitted exhibit, the weather reports, and see if he would be able to read that for the jury. It's perfectly common sense. Any average person should be able to do it. And the detective, it's to impeach the detective who sat there and hemmed and hawed and made a big deal about it.
Isn't that document in evidence?
Yes.
So the jury can see it,
Right.
can they not?
Yeah.
And if it's common sense, won't they be able to figure that out?
So you say no to it?
I mean, I just...
This is Fulton County. The correlation between common sense, taking common sense, bits of extraneous information and then extracting those and utilizing them to make a cogent thought or point has not been, well, displayed in alacrity here lately. So, yeah.
Don't know any, I mean, other than that if it's common sense, your average person should be able to read it. But if I recall correctly, the detective struggled a little bit to read it too. And so I'm not sure I understand why Mr. Wolfenbarger, hang on. I'm not quite sure I understand why Mr. Wolfenbarger would be able to understand it and relate that either. Joey Wolfenbarger.
I think that's the point. I think the detective was being dishonest. And I think if an average Joe mechanic can read it, it would impeach the detective.
Okay, you had the detective on the stand. You now are accusing the detective of trying to shade things. He was on the stand. You could have told short, angry, beard lawyer, Keebler elf lawyer, to ask him the question. You do that thing where you're like, "Can I have just a minute?" And you go, and then you come back. Actually, I did have a question. Did you know, can you read specifics off of that weather thing? Defense, I'm not here to be your mom.
Just for credibility.
Mr. Wilson, that noise you just made is not an objection.
I understand, Your Honor. Your Honor, I do object to that. I think it's been put into evidence. It's already been questioned about, and I think to have a witness read it when the jury can read it is cumulative, repetitive, and argumentative, Your Honor. So I think it's not. I don't think it would be appropriate for him to do it with his witness.
Any other tips you'd like to add? Subjective, respective, futuristically. I mean, we can throw a Sarah Boone in there.
I mean, obviously the person he did cross was Detective Callan.
Okay. I feel like you've made that document's in evidence and you can argue that to the jury and you don't need to inquire with Mr. Wolfenbarger about it, Mr. McDermott.
Fair enough. So, bring it
Anything
back
else?
here. I will say no more questions.
Okay. Could you get Mr. Joseph Wolfenbarger back for me, sir? Thank you. Deputy, we're ready for the jury again. Obviously, once we get Mr. Wolfenbarger back.
The mosey is strong in this court. It takes them like 15 minutes to get the jury in.
Your examination.
Thank you, Your Honor. No further questions for this witness.
Thank you, sir. Mr. Wilson, questions for this witness?
Yes, thank you, Your Honor. Now, you were born on July 5th of 1996, isn't that right?
Yes, that's right.
So you would have been about 2.5 when your mother went missing, correct?
That sounds about right.
And you have no personal memory of that, correct?
Not of her, no.
So you have no memory at all of your mother?
I mean, no, not like a living version of her, no. I mean, there's little bits here and there I can remember, like, of, the ceremony, but that was it, really. I didn't really understand, who she was,
Yeah, because you were only 2.5 when it happened.
Right. I mean, but it was later on when the ceremony and whatnot.
Now, you lived with your mother, you never lived with your mother.
No, not really, no.
Yes, you lived with Kathy Wolfenbarger, your grandma.
Right.
She wanted you to call her mom?
Not exactly. It was just more so it was easier that way.
So you did call her mom?
Yes.
Okay.
And that seems like something that is not at all nefarious. If you're a little kid and even, okay, take CRPS for me. People notice I limp and I have no problems going in and explaining what's wrong with me, but it does get a bit exhausting. If it's a long day or I have to explain it to a bunch of different people. So yeah, just simplifying it so you don't have to give the rundown of, well, my mom ran away. We thought she would just run away. We found out she was red rummed. This is actually my grandma. Yeah, we use shorthands. Yeah, mom, she was doing what a mom does. I don't find anything nefarious like the state's trying to put on Kathy being called mom.
And you never saw pictures of your mom at all while you were growing up?
I mean, I've seen some, but they wasn't like displayed all over. There was, the rare occasion that we would go through photo albums or whatnot, but, that's the only real time that I've seen them early on.
And those photo albums were located in the house, correct?
Yes.
Okay. And you were 4 when you were told that your mom had been murdered?
I would say that's about right. 4 or 5, somewhere around there.
And you were told by Kathy Wolfenbarger, correct?
Not really. I mean, it was more so of Rachel. Like she got more into detail with it.
Okay.
I mean,
It's
Okay, maybe not going into detail with a 4 and 5-year-old. Again, it's not my family. Maybe he was a really mature 5-year-old, but I doubt that.
So you heard a bunch of details
Yes.
when you were 4.
Yes.
And you never asked your dad about what happened, correct?
I mean, it'd always been a touchy subject for, talk about anybody, it's not really,
Okay. So you never had conversations about your mom's death with your dad, haven't you?
I mean, bits and pieces,
But nothing extensive.
right,
And that over the years?
right.
Okay.
Again, I don't think the state's making the point they think they are. I think if this is so relatively common to have things that you don't touch upon as a family, kind of let sleeping dogs lie. I mean, every family, even if it's something as silly as, a prank gone wrong or, something funny that maybe was more made fun of, or laughing at someone than laughing with someone. Every family is going to have these touchy subjects that you don't bring up. And if you're going to try to use that as guilt, then a logical juror is going to say, well, we all don't talk about, Aunt Rita's drinking problem because, she's embarrassed about it and she's trying to do better. So, yeah, this doesn't make the point that I think the state is trying to make.
And after high school, you moved in with your dad,
Yes.
and you haven't had conversations with him about it, only bits and pieces, correct?
Correct.
And you were still living with him. You're still living at that address?
I mean, not at the moment, but, I was off and on for a while, shared 2 residents.
Who was the other residence was Kathy Wolfenbarger?
Yes.
Hey, just a moment.
Sure.
That was,
You live with Kathy?
yes.
Okay. And who is Rachel?
That was the woman he got with after my mom.
Okay. So you've talked about it with your dad's girl, kind of living.
Right. They were living together and they moved in across the street,
Okay.
you know.
One more moment.
Sure.
Thank you. Real quick.
What year were you born again?
96.
96. So when Melissa's remains, or when you went to the ceremony, you mentioned the ceremony a while ago, and you said you had just faint memories from the ceremony. And that would have been in 2003, correct?
Yes.
And so you would have been about 6 or 7 at that point. What would you have been 6?
Yeah, give or take, yes, about 6.
So
Yeah, but he's not going to retain those. As a 6-year-old, you're right. Remember that you were in a stiff suit, grandma made you dress up and a lot of people were crying, but it's not that concrete to you. Again, this isn't a woman that he saw every day. The sad fact is that Melissa had already signed over parental rights to Kathy and was a negligible part of her children's life at the time that she passed. It's sad. It doesn't mean that she deserved to end up in plastic bags, but it's the truth. The reality is that Melissa was struggling with something and decided to give her kids the gift of having a stable home, which should be commended, but she wasn't a part of her kid's life.
you wouldn't have heard anything about your mother's, how she went missing until after that point, correct?
Yes.
Okay. And is your memory still fuzzy from all that stuff?
Right.
Okay.
Like I can remember like bits and pieces, like kind of where we were standing or whatnot, but, just,
And so is it safe to say that the discussions you had with Rachel would have come after that point?
right.
Okay. No further questions.
Thank you. Anything else, Mr. Wilson?
Just very briefly.
Sure.
Now you have a full sister, correct?
Can you,
You have a full sister. You have a sister.
yes,
And what's your age difference
10 months.
between you and Chrissy?
Yes. 10 months.
Okay. Nothing further.
Mr. McDermott?
I'm nothing further. You may be excused.
Thank you, sir. You can step down.
Thank you.
You are excused as a witness. Mr. McDermott, defense may call its next witness.
So, may we approach, Your Honor?
Yes.
Seems like the witness is still out and about. The police haven't found her yet. Now, the defense really wants this last witness. So they were willing to go into a continuance to get this last witness. I haven't watched ahead, so let's see if we find her.
Yes, they won't.
I'll have to go upstairs because I don't have them. No.
Okay. I'm gonna, because it's time sensitive, is it okay? I'm gonna ask that we leave that deputy here and you go take care of that while I take up some other matters with these individuals.
He has to go.
So if he goes, then I can't take up these other matters with these lawyers because he's not here.
Yes, Your Honor.
Miss German?
Does anyone else work in the Fulton County Jail? They can't rustle up another deputy to go pass along a message?
Can you get another deputy in here? Because if you leave, then
I see my problem.
thank you.
Your Honor,
Yes, sir.
I'm curious about a rebuttal. I just want to make sure the rebuttal rebuts something that occurred today, because we didn't have a case yesterday, so the rebuttal has to be something in response to something that happened today.
Obviously.
And I'm curious. I don't think they have to pre-clear it, but I guess I'm preemptively filing a motion that they don't get to just start putting up new witnesses or dealing with issues that came up yesterday or last week, or it has to be rebuttal of today, because we didn't have a case before.
I think we all know that that's what rebuttal's supposed to be.
It is.
Okay. What, though, of our other witness? They're not here yet. Mr. McDermott or Mr. Samuel, can one of you tell me who that witness is? Because I'm having the deputy check. Now, by some miracle,
Someone is coming to believe me.
thank you, sir. By some miracle, maybe he goes upstairs and finds out that that person is already in a sheriff's car and is on the way here from wherever it was that I saw that they were from, which was, yeah, far away. No, I thought it was out the west side toward Alabama.
It's Cody.
It's Covington? Okay, so east side. Okay. But that's far. In any event, so let's say
Where in Atlanta is Carmen Sandiego? Just a little life tip. Don't ignore subpoenas. You'll get a free ride and free bracelets on that ride, but it's not worth it. Take an Uber, take a Lyft, and get your behind to court.
by some miracle that person is somehow going to be produced here today. But it's very likely that that person is not going to be produced here in any reasonable time to be testifying today. And so my understanding from you, Mr. McDermott, is that it would be that y'all would be moving for a continuance. Is that correct?
Yes, Your Honor.
Tell me who this witness is and why you believe that a continuance would be justified to allow that witness to testify.
So one of the undercurrents in this trial has been the relationship between Melissa, Christopher's family, Melissa, and her family. A huge part of that is this custody battle, and I think the jury's going to have to decide at some point. One side was pressuring her to do this, and one side she wanted to be with, or maybe there's some other complex dynamics. In my opening statement, I basically said that the evidence is going to show that there's strong evidence of a very poor relationship between Melissa and her mother at the early stages of her life that ended up leading to her running away. Okay. The state has been able to counter that by presenting these evidence of these cards and the letter, et cetera, et cetera. Mm-hmm. But I have relied upon this witness to provide the evidence I need to sustain what I told the jury was going to show. And I think it's a relatively important piece of evidence to show that she did have a poor relationship with her mother. And so this witness was a next door neighbor to the Wolfenbarger, or to the Pattons.
To the Pattons.
Sometime in the 80s up until maybe the early 90s. She was best friends with Melissa. She is going to testify that all the things I said in my opening, including some that are arguably worse, that they were locked in their rooms, they were not allowed to leave to get water. Melissa was not happy. Melissa began running away with her, eventually on at least one occasion did drugs with her, and got into some other things. And she's going to testify that the locking in the rooms specifically went on from about age 7 until about age 12, every day that she came over there, all day. And there's a considerable amount more of backstory to that. So, and then at some point after the finding of the baby, Melissa started running away.
Well, that's in evidence. I mean, that part very clearly is in evidence. I've heard people discuss it multiple times, and not just through lawyer questions.
I don't need her to establish that point, but it does establish it in the context of the timeline of what she calls Melissa's neglect and abuse. She will also testify that there were times that at some point her mother would not allow her to have makeup. She had to use colored pencils on her eyes. She's going to testify that her mother would not
Yeah, because makeup was the worst of Melissa's problems.
give her feminine hygiene products, that she had to use socks for pads. And I think those are all relevant as far as illustrating the relationship and the feelings.
Norma, why the hell did you get immunity? You need to be in prison. Georgia, what were you thinking?
Melissa would have had to her mother. I cannot fulfill what I said in an opening statement without this witness. And so I think for that reason alone, not to mention the extremity of what she's going to testify to, I think it warrants a continuance if we need to have it.
Do we have any information about why she's not here?
I do. So when I initially contacted her probably 2 weeks ago, I was actually shocked that I finally got through to her, and she was effusive to me. She was like, I want to tell my side of the story. I want to tell this. She's very clear. She's not a fan of Chris, and she's not on his side in this trial. But that she said, I will show up and tell the truth. I said, well, would you testify? She said, for him, no, but I will tell the truth. And I said, if I subpoena you, will you come? She said, yes. And she, on a couple of occasions, kind of went silent.
If you subpoena, she won't show. The Field of Dreams. Great movie.
As I was trying to communicate to her what days to be here. But she came back a couple evenings ago and told me that because I think it was her stepson died at the beginning of July, she's been dealing with depression and things like that, and that she just needed to spend a day or two in bed. But she texted with me. She sent me a bunch of pictures of Melissa and them growing up. She was very open about it. I shared with her that, if cost is a problem, we're allowed to reimburse you for certain things, travel, whatnot. And she said, oh, okay, fine. And it was clear to me at that point she was going to come. And then yesterday, she didn't come. And then I contacted her last night, and she gave me a hard, trying not to use the word she used, but it was basically
Not just no, but
I think she.
I would have, there are so few times that you can actually curse in court. I love it when you can tell lawyers really get into this, where they can curse in court because of, being quoted like, hey, MFer. They just revel. So I would be like, she quote said, you thorny thunder cow, I refuse to come to your fakakta court to deal with that douchebag.
She's realized that what she has to testify to will help Chris in some way, and so now she's refusing to come. And I did not tell her I was going to send a deputy because I don't want her to run and hide somewhere. And that's the long and short of it. So the short story is that it was not until it was early this morning that I got text from her saying I'm absolutely not coming, and variations of that.
okay. So realistically speaking, though, let's play this out logically. Are we confident that even if a deputy did go to her house and force her to come here, that she would willingly testify?
I fully expect she's going to be resistant, and I would ask to treat her as an adverse witness. I have our conversation recorded, and I've made a transcript of it. So I am prepared.
Well, if she's refused to, she wasn't. She isn't available if she's refusing. But anyway, what are your thoughts, Ms. Hilton, or somebody from the state?
Not.
I'll just add, if the state will waive cross, we'll be happy playing portions of the audio.
That won't happen.
She said that won't happen.
Your Honor, we don't necessarily object to a continuance if this witness is under subpoena and can get here. So we're not opposed to the continuance, Your Honor. We would ask if we can have a copy, at this juncture, can we have a copy of the recording and the transcripts of this witness's interview so that we can prepare? So that's
It
what
was sent 2 days ago, Your Honor. They have the email.
You mean you emailed them the audio file?
Okay. Who is in charge here? You can go ahead and mark that off and what do you say you do here? Because is anyone checking their emails we need that transcript done, sent it to you. Does anyone work here?
Oh,
Yes.
thank you. Okay, so one other question that I had asked counsel at the bench, it's less than ideal, but if there is a chance, which I'm going to wait and see what I can hear from the state, from the sheriff's office about any progress that's been made to locate this person and go get her. But if there is rebuttal, is it possible we could just go ahead with rebuttal and come back to this witness if we can get her here later today?
I would not prefer that because I don't know what she's going to say, and my rebuttal witnesses may need to address what she's going to say, and so I wouldn't want to start any of my witnesses.
In fairness, Mr. Wolfenbarger did pretty much tell you what he was going to. I mean, it sounds as if the only knowledge that she could have if she knew Melissa when she was a kid is Melissa didn't get along with her parents and some specific facts about it.
But we never know what's actually going to come out on the stand. So we understand the recording, we understand what his proffer is, but I don't know what she's actually going to say, what's actually going to come before this jury. And so the state would prefer to have the defense finish their case, and then the state move forward with rebuttal at the conclusion of their case.
Okay.
This judge is like, can we get this trial done
Yes,
today?
Mr. McDermott.
Yes, Your Honor. Your patience is unlimited and admirable. And there's no reason they couldn't go ahead with the rebuttal witness, and if our witness is here or not, we can still hold her over to the next day. I mean, I'm saying we can still do the rebuttal if they want to.
Yeah, I know. So I think I know everything I need to know except for what effort, if any, has actually been made to go and find that person. So at this point, we're just going to have to let the jury cool their heels for a minute until I step off the bench so that Deputy Holt can go check, because for some reason there's not two departments that do that, right? Or Miss Deputy Holt is stuck doing it himself, even though he's also got to be in here doing this part of the job. So in any event, I'm going to take a break for a moment so that Deputy Holt can step out and see what the answer
All right,
is about
we are
this
going to
witness.
speed through this break, see if we found said, witness abscondo. Daggone, this man is in Georgia. Can we talk about the technical unfairness, the fact that his hair has not frizzed up not once in this entire damn trial? It's just, it ain't fair. Are we... Audio being stupid.
Where I can. Some of them y'all have already brought to my attention.
Okay, so we are not going to watch them argue over trial or jury instructions. Today, I'm just not in the mood, if I have to be real honest with you. So let me get
I know
day
that
7
we've
up.
had some statements come in, prior inconsistent statements come in. I know we have the prior statement charge and rules of credibility.
Justice Watchers, before we begin.
And do give Justice is a Process a like and subscribe. They do yeoman's work making clips of these trials, finding where audio works, and kind of, getting just witness by witness clips too. So Justice is a Process. If you're looking for trial streams that aren't, court TV or Law and Crime, he does a great job. And by the audio, I'm going to guess it's the he. So.
Anything from the defense?
Anything from the defense?
Okay. Yes, sir. So just to be clear, Mr. McDermott, I'm still going to ask you to call your next witness, and then I'll just acknowledge that witness is already on the stand, and then we'll swear them in as normal.
Do you want me to ask on the record permission to treat her as an adverse witness, or do you want me to make an attempt to get her to answer directly first?
I think she's your witness, so you should make an effort to see how cooperative she's going to be, and only if she's not cooperative would you then be justified in asking to treat her as such.
Are we allowing
Ma'am,
shock
come over here to the
shackles?
witness stand. And she might need some assistance getting up onto the witness stand and situated in the chair. You could. Thank you very much. Okay. So we have our witness, and so I think we're ready for the jury, Deputy.
Holy crime against eyebrows. What happened? It's like she went halfway to a full massacre of both eyebrows. Why would you stop? Why would you just think that this is a good look? Like, you know what? God gave me full eyebrows, but I just kind of like these bits here. So I will proceed to draw on, not God-given eyebrows. Those are some criminal, you know, I don't believe in phrenology, you know, the old Victorian or an Edwardian where they would test your head bumps, but I do believe in criminal brow shape. Well, doesn't she look like a bright ray of resting bitch? Are we going to have audio? Oh, you court TV. What is... All right, let's see if we get to... Oh,
You
here
remember
we go.
telling me that Melissa had some kind of... It's not a leading question, Your Honor, unless it suggests an answer.
I'm going to overrule and allow it. Go ahead.
Do you remember telling me that Melissa has some sort of skin condition that caused her to have marks on,
Intigo.
and it caused her to have visible marks on her body all the time?
Yep.
And how did you describe those marks? What did they look like?
Scratches.
Did you say bug bites, sores? Thank you. Can you remember how you described Melissa's personality to me?
Well, if I'd look back at it, I'd say autistic.
You know, Melissa having a touch of the tism was not on my bingo card. What? Okay, because this woman is the litmus test of normal.
I said, if I had to look back, I would say autistic.
Okay.
She would be autistic.
But you're not a doctor, right?
I'm not a
So you
doctor.
can't diagnose her with autism?
No.
But what made you arrive at the conclusion that she may have been autistic?
Just the way she is.
Let me describe those facts.
You know what an autistic person is. I mean,
Was
there's...
she quiet?
Sure.
Was she shy?
Yes,
Was she reserved?
she was.
Did she sometimes react?
She whined. She cried.
She whined and cried even when she was older. So are you suggesting she may have been a little bit
Of a baby.
infantile for her age?
Yeah.
Well, I'm glad this woman isn't Surgeon General. Well, you know, she was a bit whiny. Totally the tism. No, this is not how you diagnose anything. Do not take my or this lady's medical advice.
You described to me a period of time in which you would visit her. Do you remember describing a time to me when you would visit her almost every day?
Every weekend, yeah.
And that you would be locked in the room with her?
Yeah, growing up.
And did you tell me that the door locks would be reversed
They
on
would
her
be.
door? So that the lock was on the outside?
It was.
And do you remember that she was telling me that she was locked like that every day, all day?
Objection needed, Your Honor. He's giving the answers.
Overruled. Go ahead.
Do you
The judge is like, look, we finally found this heifer. I'm going to let him ask his questions and we are getting this trial done. You know, if she weren't in cuffs, I'd swear I'd have them check that bottle for vodka, but
remember telling me that she was locked that way every day, all day? I need an audible answer, I'm sorry.
Yes.
Thank you.
So was her sister. Her sister's right there.
And from what ages do you remember her being locked in the room?
I don't know, 12, 13.
Did you remember telling me it started at about age 7?
I'm sure it started early.
Went up to about 12?
Yeah.
Okay. You said her sister was locked too?
He's right there.
And she was locked?
this woman has an axe to grind against Tana Patton. Again, spelt like Tina, pronounced Tana. I am not joking, you guys. This trial is cursed. Also, children, just on a side topic, don't do drugs.
Up to? Mm-hmm. And
I'm sorry, was that a yes? Yeah, my mom used to sneak over there and get her out of the window. Thank you.
what's your mom's name?
Terry.
Terry Archer, is that correct? And
Is that a yes? Yes, it is, Terry Archer. Thank you.
what was your father's name?
Bobby.
Bobby. And you said that your parents were wealthy
They are.
and that they paid.
Is this relative wealth like of Fulton County or really wealthy? Because I have all the questions.
To be involved in several activities with you?
They did.
What kind of activities?
GYOP, Georgia Youth on Parade, Girl Scouts.
You remember telling me that anything you did,
He
Melissa had to
did.
do,
That's right.
and that your mother paid for it.
Well, that was nice.
You remember telling me that looking back on the way she was treated, being locked in her room and being deprived. Well, let me back up. When you and Melissa were locked in the room, were you allowed to come out during the day? Were you allowed to get drinks of water?
Hang on. Yeah, you're shaking your head. Is that a no?
No, we weren't allowed to come out.
And were you allowed to get a drink of water?
Yeah, we can get. What was that? We're thirsty.
Okay. You remember telling me that looking back, you would consider that she had been abused and neglected.
Yes.
Today, if someone were treating their child like that, would you call DFACS?
Relevant, Your Honor. Objection.
Probably.
Hang on one second. Sustained. Go ahead.
Now, did you move away from Melissa's house at some point?
They moved away.
They moved away? Okay. And about what age were you at that point?
I quit hanging out with them when I was 13.
Okay. And you told me a couple of events that happened with her before you quit hanging out with her.
She lost her virginity.
Ma'am, that smile on your face. Look, I'm torn. I'm a realist as a parent. I know that, high school is not, let's say, well, Richard, it's not, 90210. I know kids do things, but could you let Melissa have like a scotch of dignity, ma'am?
And how did that happen?
Object. Relevance.
Sustained.
Okay. May I approach, Your Honor?
Sure.
Relevance of teenage debauchery is being discussed at sidebar, as is apparently normal in Fulton County.
Do you remember telling me that, caught myself, was there a time that Melissa did drugs with you?
No.
Okay.
I was doing drugs.
Okay. And
Well, I mean, talk about things that Sherlock Holmes we didn't need to figure out.
because you started to do drugs,
I
you
quit hanging
decided
out with her.
not to hang out with Melissa. You need to let me finish my question. I know it's kind of slow and tedious, but that's just for the record. You gotta let me finish my question and then you answer it. Okay. All right. Do you remember at some point Melissa started running away from home?
After I quit hanging out with her.
Okay. And do you remember that there was something that led up to her running away from home?
Her sister had a steel baby.
Why does her frown even look like a smirk? Like she has a resting Joker smirk face, even though it's a frown. Maybe it's the eyebrows. Again, children, don't overpluck your eyebrows and also don't do drugs.
Do you remember after Melissa was gone that she did not keep in contact with her mother?
I don't remember that.
Do you remember telling me that you don't remember her calling her mother? In fact,
Don't say that.
Okay.
How I know that?
Well, I mean, isn't that a face for the DMV? This woman sparkles with the personality of a Spirit Airlines check-in or ticket agent.
And had you ever met Christopher Wolfenbarger?
Never.
No further questions, Cheryl.
Thank you. Ms. Hilton, questions for this witness?
Oh, actually, would not let her have anything like makeup.
Is that a yes?
Yes.
Thank you.
And what did she do instead?
Use colored pencils.
Do you remember whether she was allowed to have feminine products?
Yeah.
You remember telling me on the phone that she had to use socks.
No.
If I showed you a transcript of our discussion, would that jog your memory?
Why would I?
Okay, defense lawyer, you're assuming this woman can read and understand contextual clues, and I'm going to say the jury's still out on that one.
Say that.
Can I show you a transcript of our interview?
Sure. I never said that.
Would you like me to play the audio?
Sure.
On a serious note, I do get why the defense needed this, because your opening statement is kind of your outlining, basically showing the frame of your case. And he did make the statement in his opening statement that we were going to hear from people that knew Melissa and knew another side of her relationship with her parents. Is the jury going to, believe this woman? I'm going to say probably on the same level as Norma.
I must have been high.
What a ray of antisocial behavior.
Permission to share, Your Honor?
Okay, question. Is that a piercing or is that a mole? Because if it's a piercing, ouch. If it's a mole, ouch.
Granted, just make sure that what you're going to share is only the portion that is relevant to the question you just asked.
Well, because she was high, Your Honor, Weedman would like to represent this woman. Or Redman. Whichever the guy who sang that song.
She was. And let me tell you, like, makeup, when she would put makeup on, she would have to use color pencils because her mama did not give her those things. Like she, would have to use, I hate to say it, but like socks for pads and shit like that. Because her mama neglected.
I guess I did say that. That was her.
No further questions, Your Honor.
Your Honor, I would like to employ the 420 amendment. What I said whilst high cannot be used against me. Well, I'm finishing up after the end of this witness, Miss Weedman. Good Lord. This woman is not credible at this point. She is doing everything to... And I get it. She is pissed off that she was dragged here in cuffs, but maybe don't say that you're going to be a witness. Let the lawyer, swear out a subpoena for you, and then just decide, I changed my mind. That's not how court works. And
Thank you.
I'm guessing you're really aware of how court works, ma'am.
Ms. Hilton?
Good morning, Ms. Waddell. How are you?
Withdrawing.
Withdrawing. Okay, but you answered his questions. Have you and I ever met? Is that a no for the record?
No.
And have we ever talked on the phone?
No.
Okay. And you spoke with Mr. McDermott a few weeks ago over the phone? Is that a yes?
Mistake. I thought it was you.
Oh, no problem.
But go ahead.
But you talked to him about a lot of different things. Is that fair to say?
Yes.
Okay. And so you were her next door neighbor, correct? Melissa's next door neighbor.
As a child.
And as a child, that from between the age of 7 and 13?
No.
What were the ages?
Ages of 2 to 7.
2 to 7. Okay. And your parents are friends or were friends with Melissa?
Our friends.
And you said you spend time at her home every weekend, correct?
Did.
And you just testified that there was an odor in the home that you didn't like. Is that fair?
Oh, yes. Yes. Thank you.
But every weekend you still go to the house.
Yes, I love them.
And think you
Yeah, the logic doesn't make sense here. Again, there probably were very, very difficult and chaotic scenes going on in Melissa's childhood, but I contend that if her parents were the kind of parents that were like, hey, Melissa, you know, she gets to come to Girl Scouts with us, she gets to do whatever after school activities you are doing too. I don't think those kind of parents are also going to let you go to a house where you're locked up essentially for the entire weekend, unless it was something that you didn't talk about. So I don't know.
testified earlier that your mom would have to take Tina out the
Possibly.
window.
She would.
Okay. But your mom still let you go over there every weekend.
She did.
Now, you said
Never mind, apparently these parents are nuts because they continue to still be friends with said accessory after the fact Norma Patton in the Flint River Killer, you know, case. They're still best friends. I say if your friend's adjudicated of taking 5 lives, regardless of whether they have immunity and whether it was just disposal of the body, you break ties just a little bit.
that Melissa was able to do Girl Scouts with you. I think you told defense counsel over the phone cheerleading, and then just like a girl youth group. Is that the third thing you just said?
Something like that.
Right. And it's safe to say that her mother will let her go with you to
sure.
do these events. Right. Although your family paid for it, her mom let her participate in those activities.
She would.
And that kept you all busy. Is that fair to say?
It did.
That's a lot of activities, right? Now, at some point, is it fair to say that your mom moved to Covington and you moved to Covington?
I did.
About how old were you when you moved to Covington?
13.
And Melissa would still visit you while you were in Covington?
She did.
And so her mother would let her leave from Stockbridge? Is that a yes?
McDonough.
From McDonough and come see you in Covington?
She would.
How far is that?
30 minutes.
So it's safe to say Melissa would have to come out of the room in order to come see you. Is that fair?
No, she didn't lock her in the room like at that age.
Okay. Now, when you all were younger, did you tell defense counsel that you all never knew what Carl Patton had done?
Never.
You did not know?
We didn't. Not until they came and got him.
And when you said when they came and got him, are you talking about you found out in 2003?
I'm talking not until the police came and got him.
Okay.
That would be 2003, yes.
Now, is it fair to say the last time you saw Melissa was in 1997?
Last time I saw Melissa would be about 1998, 97.
97, 98. And I'm sorry, did your family have like an event every year and the
They did.
Pattons would attend?
Yes.
What type of event was that?
Holidays.
She really needs to stop talking. I mean, she's just overly verbal.
And you talked about Melissa.
I mean, this woman, you know, by her own diagnosis, might have a little bit of criteria, might have a little bit of the tism as well.
Melissa's kind of demeanor. In your opinion of knowing Melissa, would she ever just leave her children?
No.
Would she ever just stop talking to her children?
No. Not that I'm aware of.
Now, when you spoke to Mr. McDermott, you described Melissa as not bright at times?
No.
No, you didn't, or no, she
Yes.
wasn't? I'm sorry.
Yes, she's not right.
Okay. That she was easy to control?
She was.
You said that she was weak?
She was.
You said that she was submissive?
She was.
You described her as a type that would not fight?
She don't.
That she was very naive?
She was.
Not a smart thinker?
Not a smart.
Wait. And you're a Mensa member, ma'am? I mean, I trust Sarah Boone's academics, her being, you know, an honor roller in high school, more than I, you know, accept your intelligence bona fides, but there you go.
You said that she's dependent on whoever she is with.
That's right.
That she would not be the leader in a relationship.
She would be.
Matter of fact, in your friendship, she kind of follows you.
She did.
And you said kind of after you left, Melissa had no friends.
Right.
Now, I know you just told defense counsel that you never saw Mr. Wolfenbarger, but you had the occasion to speak to him one time on the phone.
Well, I guess very short, he would let me talk to Melissa.
Tell the jury about that.
He just wouldn't let me talk to her.
When was it?
In 97, 98,
Do you recall telling Mr. McDermott that was around Thanksgiving 1998?
something like that.
And that you actually called to speak to Melissa on the phone?
I did.
And Chris answered the phone,
He did.
and he wouldn't let you speak to
He
her.
wouldn't.
And he was controlling her ability to talk to you.
He was.
And it's fair to say that at that call, he did not want Melissa to talk to one of her childhood friends.
Objection.
Sustained.
It's true.
If there's an objection and I sustain it, you have to not answer the question,
Sorry.
okay? Thank you.
And was that the only time that you talked to Chris in Thanksgiving of 1998?
Yes.
This woman chose full joker. She is going to put a fork in everyone, including Chris, the defense, the state. I mean, this woman chose violence when she came in. She's not a believable. Look, if I'm in the jury, I am not taking anything this woman says seriously. She's treating it like a joke. The least that you would expect from a friend. I mean, yeah, I have a wicked sense of dark humor, but if my friend was unalived, I would not be all glib and disrespectful. If I truly thought that the information I had could help in anything, I'd be there. I wouldn't be making glib little jokes.
Court's indulgent. Sure. No
Okay,
problem.
thank you. Mr. McDermott, any additional questions?
Yes, ma'am. You just told the state counsel that when you talked to me on the phone, you thought it was them.
I did.
Is that correct? And didn't I tell you on the phone, I'm Christopher's attorney?
Nope. You said defense.
Okay. Permission.
Same difference. Defense would mean he's representing the defendant, Christopher. Prosecutors are usually called district attorneys. Ma'am, you cannot sit here with a half smirk, stroke smirk, and tell me you don't know which parties are which in a court of law. This is not your first time in a jumpsuit, I'm going to go ahead and guess, and in shackles.
Play some audio, Your Honor.
She said you said defense.
Okay. So I did tell you.
Just making sure you heard her answer.
I did tell you I was the defense attorney.
You did.
Correct. And then I told you I'm Christopher's
You
attorney.
did tell me that.
Okay, thank you.
Afterwards, yes.
At the very beginning of the conversation.
Look, I get high every day. I do drugs. So I'm just trying to tell you, I don't know, what I say. And I hate to burst your little bubble. I'm just telling you, like, I do heroin every day. And I'm going through withdrawals.
Okay, well, I mean, you are aware you're on the record. So if you were trying to keep your little H problem under wraps, you kind of done confessed on stand.
And that's the whole point. I didn't want to come here. So I don't know what this would be.
Well,
Were you on heroin when you talked to
I
me on the
was.
phone? You on heroin right now?
Only because I'm locked up. Sweating to death.
Just to reiterate, you quit hanging out with Melissa around age 13, correct?
I did.
So you had really not much interaction with her after that?
I didn't.
Okay. So you don't know what she was thinking or doing after that age?
No.
No further questions, Your Honor.
Thank you. Ms. Hilton, anything else?
well, I am going to leave it for there. But I think that if we can learn one thing today, it's kids, don't do H. Because you might be, subpoenaed, forget that you were supposed to be in court, dragged in, and go through the DTs in county lockup, in Fulton County lockup, which is terrible. We will be getting to the state's rebuttal case tomorrow. It looks like they only have one rebuttal witness, and then we will be doing closing statements. But there you go. I'm going to go out to get not to get gummy nerds, not anything illicit, but junk food. So I will see you all tomorrow. Actually, I will see you all this evening. Don't forget, on the stream tonight, we will be continuing to hang out with Shizzy and go over the Coburger, Idaho Police Department documents. It's a case that neither Shizzy and I covered. We were waiting for the trial. Obviously, the trial didn't happen. So we are hoping to get some answers that we would have gotten in the trial and just kind of go from there. So if you want to maybe learn that, it is at 6 p.m. tonight, 6 p.m. to around 8. So about a 2-hour stream. So we will be hanging out and discussing, the latest Coburger news. It looks like he's going to have to pay the victims a little bit more money. Hope he's good at making Levi's. But there you go. Thanks for joining the Petty Express. We will be back on the track again tomorrow with rebuttal and closing statements. Pray for us because the state has the first and final closing statement. May the Lord be with us all. Bye, you guys.